MCL 765.6 does lay out that the defendant would be entitled to bond, and that bail shouldn't be excessive if not addressed by some other statute. On the list of no bond acts, allegations in Michigan, I'm not sure that this qualifies as a no bond.
I had a concern that a 2-year R&O would qualify for no bond. So let me look at the rule.
Hey there, welcome to the Courtroom Files. So one of the things we see a lot in the comments on our videos is people saying, why didn't the judge do this? Or why didn't he do that? Or if I were the judge, I would do this. And often those comments revolve around bonds and bail. Why did the judge grant this guy a bond? Why didn't he? Things like that. So this video from Judge Middleton's court explains some of that. He has a defendant in front of him with a whole lot of things going on, and it is Judge Middleton's initial idea to just deny him bail, but then they have a discussion about why that may or may not be possible. So we like Judge Middleton because his court tends to be one of the most educational ones. He talks through everything. So at the beginning of this video, you'll see what's going on with the defendant, then they'll get around to the concept of bail for him, and they talk it through, and it's very educational and entertaining. So we present it for those reasons. Let us know what you think in the comments about how this ends and how Judge Middleton arrived at his decision. Consider subscribing to the channel if you haven't already. Put a thumbs up on the video if you enjoy it, and let's roll the game film.
All right, Mr. Fleming, thank you. Everybody is back. It's time to start this arraignment. This is called a bail setting arraignment. Sometimes we refer to them as jail arraignments, but it's to get the case started after your arrest, advise you of the charge, and set a bond. The prosecutor filed a complaint this morning, I think, alleging that on or about Christmas Day, December 25th, you did assault, batter, wound, resist, oppose, or obstruct Nathan Johnson, Brian Freds, and Joshua Edgington of the Sturgis Police Department. Those are all felonies punishable by up to 2 years imprisonment. It's also alleged that you are a habitual offender with at least 3 prior felony convictions, making this a 4th offense, which on a 2-year, I believe, makes it a maximum of 15 years imprisonment. Prosecuting Attorney-elect Deborah Davis is here with us, and you met with the public defenders, Keith Stickley, the chief public defender, and his assistant, Larry Westcomb. Ms. Davis, let me ask you this. The bond information sheet refers to a fleeing and eluding incident earlier in the day. There's no fleeing and eluding component to this.
Your Honor, there is a warrant request for fleeing and eluding from Officer Joshua Wired from the Sturgis Department of Public Safety that is in review. There were some questions about jurisdiction and other charges that may be associated with this. There was an incident in Sturgis, which is what brought the police to the place where he lives, and he then was seen in his vehicle. And there are 4 separate jurisdictions that have potential fleeing and eluding charges, all from yesterday's incident, which is why I'm here to advocate for some bond conditions and potentially not allowing bond in this case because of the danger to the public that this individual presents. So I don't know if you want me to go into that.
Go right ahead.
Sure. So this particular defendant was just released from parole recently. He was on parole from an incident of resisting and obstructing, causing injury to an officer here in St. Joseph County. He has several prior domestic violence charges, including domestic violence third and a strangulation. He has been charged with absconding previously because he hasn't appeared, and his behavior yesterday is extremely reckless and dangerous. This started in the early afternoon. It's alleged that his significant other, who was the victim of one of his prior domestic violence charges, had called the police to assist her because he was being violent and breaking things at the home. And she alleged that he is using methamphetamine again since he's been off of parole for a few weeks. So with that, the officers waited to see if he would come back because she said he had left driving erratically. He did, in fact, pass by the officer on Nottowell Road going 100 miles an hour in a 45-mile-an-hour zone. It's alleged that at that time, Officer Wired did pursue the defendant, but that pursuit went through multiple townships and the village of Baroque, and then into the state of Indiana, where it had to be terminated. Shortly thereafter, it's alleged that LaGrange picked up, they found him, and he then fled from the LaGrange officers back into Michigan. It's alleged that they then lost him again, and then he went back into Indiana and then came back to Michigan, where St. Joseph County deputies found him and pursued him, where they lost him again. And then Officer Wired in Baroque Township found him again and pursued him. But because of his driving being so dangerous, passing people on the right side, that sort of thing, they terminated the pursuit. And then a tip led them to find him last night in Sturgis at the American Inn, which is where this RNO ×3 was alleged to have occurred, because he refused to come out of the hotel room, physically was holding the door shut, preventing the officers from unlocking the door. And then they found him in the bathroom, again, not coming out with the officer's lawful commands. So as far as the danger to the public, I think as far with his driving and the issues, he does have a valid license, which is surprising based on the fact that he has 3 prior OWI incidents in different states. He has criminal history in several different states, including a flee and elude in West Virginia, and some incidents in Indiana, multiple different instances of use of controlled substances and assaultive, threatening behavior, multiple prior assaulting, resisting, obstructing of police officers, although some of them were dismissed as part of plea agreements. He is an extremely dangerous person in the view of the prosecutor's office, and we would ask that the court consider not allowing a bond at this point because of the danger to the public, as well as the likelihood that he is not going to appear. And if he doesn't appear and a bench warrant is issued, it could be an extremely dangerous situation for the law enforcement involved, as well as the public, if they have to go out and chase him and find him again. Again, there's also going to be at least the flee and elude from Sturgis that is under investigation because of the potential for the methamphetamine, potential for an OWI or OUID. There was some further investigation that was supposed to take place this afternoon. I'm not sure of the status of that yet. So we went forward with just authorizing on the resisting and obstructing, which we're prepared to have a trial on those pretty quickly. If the court wants to set it quick, we can. I would rather have this individual stay in custody and not be able to have access to vehicles or substances, so that we can have a trial sooner rather than later. And because he is a 4th habitual, the fleeing and eluding will likely be a potential life offense.
All right, the fleeing and elude could be a 5-year with a 4th habitual. Mr. Fleming, the public defenders are here with you. Let me ask you a couple questions. I show your address as North Street, Sturgis. Is that correct?
Yes, sir. Yes, sir.
All right. So the room at the American Inn, Mr. Mr. Cannon's room, you didn't reside there. You just happened to be there.
Mr. Fleming, I'm going to advise that you not answer that question. All right. Your Honor, we would ask that the court respect Mr. Fleming's right to stand mute, have a not guilty plea entered on his behalf.
All right.
And then we have we would have a brief, I guess, rebuttal in terms of bond.
All right, Mr. Fleming, in interest in protecting any of your rights, the public defender's recommendation is you don't say anything. And some of it may be moot because I'm going to deny your bond. So there's no point in asking whether you're employed, I guess, or where you live. I'll speak to the reasons for it here in a minute. But Mr. Stickley's advice is probably wise. So at this point, I'm going to show you stand mute, plead not guilty. I'm going to appoint an attorney for you. I'm going to set a pre-exam conference for January 7th of 2025 at 8:30. Pre-exam conference for January 14th, 2025, if needed, at 1 p.m. Mr. Stickley, what else would you like to place on the record here?
Your Honor, the only other thing that I have to place on the record this afternoon is that the defendant understands that the court might have reservations about what kind of bond might be set. MCL 765.6 does lay out that the defendant would be entitled to bond and that bail shouldn't be excessive if not addressed by some other statute. On the list of no bond acts, allegations in Michigan, I'm not sure that this qualifies as a no bond.
I had a concern that a 2-year R&O would qualify for no bond. So let me look at the rule. But go ahead.
And that is my statement, Your Honor. I was not able to find where resisting and obstructing an officer was one of the enumerated no bond conditions as referenced. I know the general overall rules MCL 765.6. I was trying to find, as you know, it's broken out a little bit helter skelter, but
yes.
I don't believe that is a qualifying offense to a no bond condition.
All right. This happens a lot. The courts will set a bond at $1 million. And what they really want is they don't want the person to bond out. So rather than say no bond, they set a very high bond. That's somewhat disingenuous. The legislature is working on some bail reform statutes that I don't think got over the hump at the end of the last session. And talking about eliminating different types of bail. Anyway, the case is aggravated. You're a very angry young man, have been for some time. I'm not sure everything that's going on here recently, but you have several previous assaultive offenses. 2013 assault, great bodily harm, bound over to circuit court. 2014 809 FY, 2 counts of resisting and obstructing, bound over to circuit court. 2014 941 FY, absconding on that R&O charge, bound over to circuit court. 201920 assault, great bodily harm, felonious assault, resisting and obstructing with an injury, and fleeing and eluding. That was bound over to circuit court and you went to prison. That's the one you're on parole, just got off parole on. File 201972 was a domestic violence third offense felony charge, bound over to circuit court. You had an assault and battery and MDOP in my court in 2021, I think, while the other case was pending, and you never ended up paying the fine and costs. Ms. Davis also indicated there's some out-of-state charges, including a fleeing and eluding in another state. The resisting and obstructing here is not that egregious. You went into some other guy's hotel room and wouldn't open the door for the police. It's like a child hiding their head under a blanket thinking maybe nobody would see them. And then it read like a bad movie where you're hiding in the shower. They should have turned the water on. Anyway, that's how you finally got arrested, and they were resolute in their attempt to take you into custody. The reason that I considered, well, all of this stuff, but there are more charges coming, and it would be not a great situation to have you bond out on this and immediately get rearrested on some new charges. So my intention was to deny the bond, at least until the time of the pre-exam conference on January 7th, and see what else gets charged, which would be more honest than setting a very high bond that you couldn't post. But Mr. Stickley pointed out a fear that I had. There are certain cases you can deny bond for, and I'm not certain that the actual facts of this case, where you wouldn't open a hotel room door, generally wouldn't merit a denied bond. You've got a bunch of baggage in your past and a bunch of baggage in your future. But there's good reason, public safety reason, to not let you bond out pending the new charges. So we will set a bond as Mr. Stickley requests. Bond set at $200,000. Cash or surety. This sounds like methamphetamine with a capital M, but we'll see how it plays out. I'm glad no one was hurt. Yes, sir.
There's no drugs involved.
All right, well, that's a plus. Just anger, I guess. And you and I have discussed it. You're angry. So, I mean, you drew a crappy hand. I'll grant you that. But this isn't the way to resolve it. Billy Joel wrote a song called Angry Young Man. I used to have the lyrics, had the lyrics taped inside my briefcase when I was in law school.
You remember me when I was a kid?
Yes, I do. I remember your brother and your sisters. That's what I'm talking about. You get
brother. I don't have a brother. I got a sister that was molested. Now
yes,
you
I
remember?
remember. I was the guy that prosecuted the case.
Yeah, I know you was. You was the one that let him off.
I didn't let him off. He ultimately was convicted. He was acquitted in the first case, and we had a second one. That was almost 40 years ago. And no, I didn't let him off. He ultimately, I believe, went to prison.
No, he didn't. You let him off. Child molestation.
All right.
You let him
All
go.
right.
Let's
Hold
tight.
all right. Anyway, we'll leave that song lyric for another day. No drugs and no alcohol. No driving. Test if directed. I don't think you're going to bond out. We'll see what comes of these new charges. Yes, Mr. Fleming, I remember when you were a kid and you got a lot of pent up anger you're still dealing with. All right, sir. I'll see you on January 7th. Your attorney will come out to the jail and see you.
Thank you, Ron.
Thank you. The line goes, I believe I've passed the age of consciousness and righteous rage. I found that just surviving was a noble fight. I once believed in causes too. I had my pointless point of view, but life goes on no matter who was wrong or right. I'm going to put that last part on my tombstone. Life goes on no matter who was wrong or right.
Hey, thanks for watching. If you enjoyed that video, do please take a moment to like, subscribe, and leave a comment on the video. We'd really appreciate that. And if you want to keep the fun going, check out the video on the screen right now.